In workers' compensation in North Carolina, it's an administrative process. And what I mean by that is it is governed by the North Carolina Industrial Commission. It is not a civil process in North Carolina. However, based upon the adversarial nature between any type of insurance claim, there is still a plaintiff and defendant in workers' compensation. Although you're not legally suing your employer, you have an administrative claim that you filed with the insurance company. And so there is a V in between the injured employee and the defendant employer. At any point in time during the monitoring or advancement or prosecution of your claim, there becomes a potential for some type of issue between you, the injured worker, and your employer. Those different issues can be as large as they denied your claim and they contend you're not entitled to benefits. However, you contend that you were injured on the job and that you are entitled to benefits. Those types of issues are handled through the Industrial Commission. Other issues that we commonly see are disputes over recommended medical treatment, such as a recommended MRI that the insurance company doesn't feel is necessary for whatever reason, referrals to specialists that the insurance company doesn't feel is necessary for whatever reason. All of those different disputes are resolved by the Industrial Commission. However, once you file your request for a hearing so that the Industrial Commission can potentially review that dispute, every case in North Carolina is ordered to mediation. Mediation is a conference that is ultimately ordered by the Industrial Commission following that request for hearing. The parties generally select a mediator of their choice. The two sides agree upon someone that they feel would best be suited to resolve the disputed issue between the injured employee and the employer. Once the mediator is selected, then a schedule is determined as to when the mediation will take place. And the legal terminology is a mediated settlement conference. This scheduling date is a cooperative scheduling. Everybody makes sure it is convenient to all parties involved. So generally is approximately 3 months after the request for hearing. The parties come, whether it be in person or virtual, they all come together and they spend that allotted time working on the issues that are before the Industrial Commission. Most of the time, this is where settlement is discussed. And when I say settlement, I mean a resolution of all aspects of the workers' compensation claim. Sometimes it is specific to certain issues. However, we generally find that when all parties are coming together for a mediation, it is an attempt by all parties to try and resolve all issues for a lump sum settlement to resolve the claim between the injured employee and the defendant employer. The whole process usually takes between 3 to 5 hours. Obviously, they can go shorter and they can go longer, depending on the nature of the injuries, the nature of the issues, and the overall complexity of the claim. Once the mediation is moved forward and all parties discuss the different aspects of the claim either resolves in whole or in part, or it moves further to a hearing. In North Carolina, both parties have to agree to settle a workers' compensation claim. The injured employee can't force the employer to settle. and the employer can't force the injured employee to settle. The mediator is simply a coordinator of the conversation. They're not a judge. They're not an arbitrator. They don't make a decision at the end of the mediation that one side is right or one side is wrong. At the end of a mediation, nobody ever decides which side was right or which side was wrong. It is a compromise by both parties to resolve the claim. And as I said, if it doesn't resolve, then it moves forward to the Industrial Commission, where a deputy commissioner will review those issues and disputes for a determination as to which party is right and which party is wrong.